Saab is a senior counsel. Let's see what his view is. Can we remand the matter to the Supreme Judicial Council, or we can't?
My Lord, may I very humbly make a submission? It cannot be done because now there is nothing for the Supreme Judicial Council to inquire into, because the petitioner's tenure has already expired. He is no longer, it goes back, he would no longer be a judge to be considered for purposes of removal, which is the function of the Supreme Judicial Council. So it does not fall within the functions of the Supreme Judicial Council at this stage. This is what my very humble submission.
So what is the solution? None?
This matter requires the determination or not?
Let's suppose we, for sake of argument, don't take it amiss, that we set aside the order. That means that that's implied in the order that all that he said, the judge, when he was a judge, was true. So you are condemned. Won't you be condemned?
It doesn't imply that, my Lord.
Why? Did he say everything I said was true? Therefore the order was set aside?
Yes. What he said, my Lord, so far as the allegations against specific persons are concerned, they came up for the first time before the Supreme Judicial Council.
No, he's been saying it from day one.
No, he hasn't. The specific allegations against persons, by naming them and naming the incidents also, they never figured in the speech, they never figured in the preliminary reply that was given to the Supreme Judicial Council. It was in the second reply, the additional reply that...
No, but one way or the other, why didn't the Supreme Judicial Council say something on it? They could have asked him, say it on oath.
Yes. What did the Supreme...
I don't know, I called you to cross-examine him. I don't know, whatever way.
I'll make a submission. What the Supreme Judicial Council did was, they asked for the then Chief Justice of Islamabad High Court for his reply on the allegations that were made by the petitioner vis-a-vis him. And he denied all those allegations.
But it's one denial,
I'm just making
one assertion.
Yeah. No, but more importantly, may I make a submission? I'd said that before also, and I'm trying to be as balanced.
See, you can't just say because he's Chief Justice, I believe him, and because he's a simple judge, I disbelieve him. That's no...
Now we come back to the speech itself. The sole ground on which the matter against the petitioner could have been sustained, this order can be sustained, is if this honorable court comes to the conclusion that that speech per se was sufficient for his removal because it came within the definition of misconduct.
Are you suggesting a judge cannot give a speech to a bar counsel?
No. What I'm making a submission. May I make a mistake? Irrespective of whether it was true or not what the petitioner said, irrespective of that, because it maligned the judiciary as a whole.
How does it malign the judiciary?
Let's go through the speech itself, if your lordship would. It maligned the army institute, the armed forces.
He is maligning you.
No. Not in the speech. In the speech, it is the armed forces, it is the judiciary. They are the judges of the Islamabad High Court.
Suppose the allegations are true, then what will happen?
Even then, the petitioner should not have gone public or made a speech before the bar.
Why?
He could have issued a contempt notice.
Why are you saying he should not? Unless you can specify some violation of some law, constitutional provision, or a constitute of the code of conduct of judges, you can't just say he should not have. You should refer to something because of this reason.
The code of conduct says something to
refer to that provision which says that judge cannot give a speech to the bar counsel or
it's
whatever.
Not a question of giving a speech, it is a question of giving a speech which maligns the judiciary.
Exactly, it's the contents of the speech.
Or which maligns any institution in the country. That is
okay, let us
only that has to be held.
एक सेकंड खान साहब एक सेकंड. Please refer to the code of conduct. Code of conduct मुझे निकालने. Which provision are you relying upon?
But may I very humbly submit, my lord, I am not taking sides in this case.
No, I know.
Because your lordship is called on.
No, actually, yes. It's always beneficial to have a senior counsel like yourself.
I'm just...
Because we are just thinking aloud how to proceed.
Yes.
And we'll be next be calling upon the Attorney General as well. So, provision can you bring him under?
There's one provision in the Code of Conduct, Hamza, which relates to public speech.
Article 2 up. Maybe you can read Article 2.
I'll read that and then... I'll read Article 2 for your lordship, my lord, but I think there's another provision which talks about, this number 5. Yes, it's Article 5. May I very humbly submit? If it is to be stressed, it will fall under Article 5, nothing beyond. I will come back to that also. Functioning as he does in full view of the public, a judge gets thereby all the publicity that is good for him. He should not seek more. In particular, he should not engage in any public controversy, least of all on a political question, notwithstanding that it involves a question of law.
It's not publicity he was seeking. He was, let's call him a whistleblower. Every whistleblower, you will say, is seeking publicity. What publicity he was seeking by this? You are assuming he was seeking. Burden will be on the person seeking his removal to show that he was seeking publicity. It's premised on that. As a judge gets all the publicity that's good for him, he should not seek more. So then it will be you are seeking publicity. In other words, you can't address bar councils. Yes, there'll be the media there. So what?
Not engage in any public controversy.
No, it says least of all on a it's not the public, it says political question. Where is politics here? There's no politics here.
It states in particular, he should not engage in any public controversy,
so if
least of all on political matters.
Let's take the worst case scenario. If the institution he is in, there is corruption, he should keep quiet.
No. So
what should he do?
He should be writing to the Chief Justice.
Okay, he says failed.
He should be writing to the
failed.
And if there is somebody,
then what should he do? He should keep quiet about it.
If there is someone approaching him, he has the power. He can issue contempt notice to that person. If anybody dares to approach him, to influence him in any of his decisions.
There's corruption, for instance, not this case, we are giving a simple thing.
What I'm saying,
and his colleague is taking a bribe. He writes to the Chief Justice, he informs the Chief Justice, doesn't do anything. He gets frustrated. Okay? Maybe the frustration level comes to a point that I'll go public now. Okay? So, fine. You can, the person against whom he is alleged and himself, you can certainly hold him to task by saying, prove this allegation. And the other person who's alleged it will say, you made a false allegation, I'll show it. Which is exactly what's happened in this case. So which other article can you rely upon?
This is the only article, I suppose, my Lord. There is an article which was invoked in the order itself.
Which one was that?
Kindly read second para of Article 2.
I'm going to read that. Right. Second para,
Second para of Article 2.
In the matter of taking his seat and of rising from his seat, he shall be punctilious in point of time, mindful of the courtesies, careful to preserve the dignity of the court, while maintaining an equal aspect towards all litigants, as well as lawyers appearing before him.
He should be careful to preserve the dignity of the court.
Yes. This is all. My Lord, I think
you are saying it comes under this too?
Lord, what I'm saying is that these are the provisions which can be...
No, tell me which one.
My Lord, I said Article 5 and Article 2, subpara 2 also comes within that because... My Lord,
we have an advantage in having you before us.
My Lord, I'm grateful for
the advantage is... You are now well versed with SJC matters. Okay. The other SJC matters where you are proceeding again. One is finishing a complaint. Right? You don't have to inquire into great details of every frivolous kind of allegation. You can just dispose it off, consign it to the record or whatever it's called. But where are you proceeding against a judge? Why you proceed against judge? With a view to remove him. So you have to give him some... here you may be conflicted as a lawyer. I'm not saying conflicted in this case, because your contentions at other place may be different. You will say, establish this thing. Fair enough. The burden on whoever lies the burden will establish it or not establish it. It doesn't get established. Clean bill of health.
देखिए आर्टिकल 2 सब इसके सेकंड पैरा में लिखा है टू प्रिजर्व द डिग्निटी ऑफ द कोर्ट. जो एलिगेशन इन्होंने लगाई है वो तो डिग्निटी ऑफ कोर्ट के अगेंस्ट है, तो इसको प्रिजर्व कैसे करें ये आपसे पूछे. उन्होंने एक तकरीर में कर दी. दूसरा तरीका आप बता दें कि कैसे कर सकते हैं।
नहीं, उसका तरीका मैंने बताया ना, जो एलिगेशंस लगा रहे हैं, व्हाट इज again, let me again reiterate, I'm not taking sides. I'm saying if it can be stretched, that speech and conduct in terms of that speech can be stretched, it could at best fall within these articles, and there's nothing beyond that. Article 5 and this para 2 of Article 2. And this is for this honorable court to decide whether that speech, irrespective of whether it is based on truth or otherwise, comes up to that standard of falls within this mischief or not. That is all. As far as the inquiry part is concerned, that did not take place. So there were, and those specific allegations are not there in the speech. The order itself, when we read page 70, we read the conclusion, it is basically focused on the speech itself, which is said to be the reason why the removal is being recommended. It's not the question of any other issues that were raised there, because they were not inquired into. Yes, to the extent of the Honorable Chief Justice, the reply was sought, and that reply came, and whatever the Honorable Chief Justice said was against what the petitioner was contending.
Did the Chief Justice, was he examined?
No, he gave a letter. So it's all a question. If this is a matter which goes on to inquiry, then yes.
But then it will mean that there must be a standard why you are believing the Chief Justice and disbelieving a judge.
What I'm going to saying is, going back to the observation.
Is it the status which?
No, not at all. Not at all. It was just, I am not even supporting that. I am not supporting that because the Honorable Chief Justice said something, therefore believe him and not believe the other. I'm saying if this Honorable Bench comes to the conclusion that in this matter, irrespective of the contents of the inquiry itself, the speech itself, and that it was made publicly addressed to a bar association, which was then, this is fine, this is all right, this does not amount to misconduct, then the order that this honorable court has to pass, the way to move forward, is to exonerate him of the charges of making a speech which does not come within the ambit of misconduct. It does not imply that whatever he said was true or that it necessarily needs to be inquired.
If you read the order, it is 39 pages of the order.
Yes.
Content is there. If there was no content there, I mean, I would find it very strange that the mayor making of a speech.
I have submitted, my lord, that in the order itself there is a mixture of the presumption that what was being said by him in terms of allegations were not true, without an inquiry. I've already said that is part of the order itself. Okay. What the conclusion would be then, that this particular list would come to an end with the petitioner being exonerated of the charges, the order being set aside, the recommendation being quashed, and he gets whatever he gets. But beyond that, if this honorable court wants to go into whatever the petitioner it has to go out of this list.
Khwaja Sahab, this nation has suffered enough. Now, it's not a question of granting relief to a particular person or withholding a relief from a particular individual. As far as I'm concerned, that's least of my concerns. My concerns are the integrity of the institutions. The allegation level is true. I mean, the nation wants to know the truth of the matter. This person is telling the truth or that person is telling the truth. You say, no, forget it. Leave it aside. It's not a small matter of a small office holder post. It's a institutional matter. Let me ask you very candidly, as a senior lawyer, would you not want to know the truth of the matter, that the petitioner is telling the truth or your client is telling the truth? Just as you have invested your life in this profession. Yes, would you not want to know the truth of the matter?
This is exactly what I'm saying. I am with your lordship on that.
How will you get to it?
What I'm saying is that not in this list, not in the case before
how do we do it?
That your lordship takes suo motu action or takes some other action, but not. It cannot be.
इनकी एक तजवीज़ आई है कि send it for review, back to remand it to the Supreme Judicial Council, that Article 209(7) was not complied with, and 205 and 6 all use the word inquiry, and 7 says you cannot remove it unless you follow the procedure. So that was not done. Without this court determining it, could the Supreme Judicial Council re-examine it and determine it once and for all whether, I think the nation needs to know whether the allegation is true or false. Leave aside your interest and his interest. There is an interest of the nation. You come from an institution which is paid out by the public exchequer. The petitioner comes from an institution which is paid out of the public exchequer. These institutions are not for your personal benefits. They are there to serve the people. So what do we do with it? People will make fun of it. What have you come up with? Result? Who was telling the truth in this matter? Because the truth is diametrically opposed. He's saying one thing, you're saying the opposite. It's not a question of variation of the truth. He misunderstood me, I meant this. Then we could have maybe reconciled both versions. तो ये जरा बताएं, इसको solve करें.
जैसे गुजारिश की, what my learned friend has said, if he has proposed, if he is sticking to that the matter can go back to the Supreme Judicial Council.
Can it? I
see a legal impediment that the Supreme Judicial Council is not cut out, is not constituted, it's not part of the Constitution for the purpose of making an inquiry which does not involve the recommendation made to the President for removal or otherwise of that of a judge. That part of the function has already come to an end.
Are you then suggesting a complaint is filed against a judge, or as in this case by the registrar, whatever you want to call it, without inquiring into the complaint, Supreme Judicial Council says he is removed, recommends to the President, remove him. That's it. End of story.
The petition is here for the purpose of getting it quashed precisely for this reason.
नहीं, quash की बात नहीं आएगी. I'm saying that is the one person, but this is not a matter of one person. It's a matter of the independence of the judiciary, which the people of Pakistan have invested into it. They're not interested in a judge serving or not serving. This matter has gone into the public domain now. It has to be, the public has to be satisfied one way or the other. Who was telling the truth? Or truth doesn't matter anymore. I keep emphasizing on truth. If he's truth, I think all the maslas will go away.
Just as it was open.
Aren't you personally interested just to know?
No, yes. May I make a submission?
Isn't it burning inside you?
But not within the framework of law, within the framework of constitution, yes. We all want to know the truth, absolutely. But we have to remain within the frame.
Which provision prohibits such an order? I'm just thinking aloud.
ये जो केस है आपके पास
नहीं, ये ऐसी जनरल बात कर रहे हैं. अगर एक और कल को केस आ जाए, कंप्लेंट हमारे पास पढ़ने नहीं बहुत सारी पड़ी हुई है, आती जाएंगी, मुझे कोई जज नहीं पसंद है, मैंने कहा चलो हटा दो इसको, सारे हमारे सुप्रीम जुडिशियल मेंबर्स अग्री कर लें, हाँ हटा दो, कोई हम इंक्वायरी करें कुछ ना करें, आपको बस खत्म हो गई बात, अब कुछ नहीं कर सकते.
पिटीशन आती है, एक पिटीशन.
अगर देखिए, एक बात है सब्स्टिट्यूटिंग योर ओपिनियन फॉर someone else, that's a different matter. The other is inquiring into the matter. Even a murderer has committed murder in front of everybody, you still have to go through the process. Even if someone commits murder right in front of 100, 200 people sitting in this room, we can't just say hang him. No, we'll have to frame a charge, we'll have to bring witnesses, we'll have to give an opportunity for cross-examination. Total waste of time, you will say. Yes, that's what rule of law means. Total waste of time. Sometimes it amounts to that. I'm just trying to, each decision creates a precedent. So where should we go now from here?
They keep saying, my Lord, the order gets quashed if dishonorable bench comes to the conclusion.
Then the nation will hold us accountable.
Necessary, notwithstanding the allegations made.
If you have finished, can we request the Attorney General?
Yes.
Okay.
I made my submission.